Most people don't read the state budget, and that is for sure. But this summer, a few things changed in New York that could directly affect what happens if you're hurt in a car crash on a job site or on the job. That's what we're looking at more closely in this episode of That's the Law. So pay attention, because this is all important stuff. Now, the biggest change, and they call it tort reform, I call it tort deform, or the law of unintended consequences, because the governor and the legislature agreed to this series of changes to car accident laws. Now, you're going to say, does that make any difference to you as a consumer? Because they promised that these changes were going to result in lower car insurance rates. Well, unfortunately, I would bet that that is not going to happen. And we can discuss at the end why that's not going to happen, because the reason for New York's car insurance rates have very little to do with what these changes in the laws accomplish. I will speak at the end about what I think the biggest problem with rates in New York are, but let's talk about the changes and how they affect you, and it's important, because I'm going to give you some important examples. You think, oh, it may not affect me. What difference does it make? And maybe my rates will go down. Well, we'll see. Sometimes a blind squirrel does find that nut somewhere, but I'm not sure. But anyways, the first and most obvious change is that for car accidents only, New York's so-called pure comparative negligence rule has been modified to a greater than 50% fault rule. Now, what does that mean? For every other kind of case in New York, it still says the same. The same rule is that if you are in litigation and you have a plaintiff and a defendant, or a plaintiff and multiple defendants, the jury decides what percentage of fault each party has, and they are responsible for their share. And the defendants are jointly and severally liable for the entire amount of a verdict. So that means if you have a plaintiff and a defendant, a plaintiff could be found 25% at fault, you could be found 99% at fault, and would get 1% of whatever the award was, or 75%. That's pure comparative fault, and it applies to all other cases now except car accidents, where this law changes it to if you are 51% or more at fault, you get 0. Okay? And I can say, first of all, people who bring personal injury claims, I'm sure that's what they were thinking about. But what they weren't thinking about is the property damage part of this. Say you're in a car crash, your car is damaged, and you think that the other party was 60%, 70% at fault. You were a little bit at fault. But the insurance company and the other side says, oh, no, it's mostly your fault. They now have a very easy position where they can make it a no pay. You're 51% at fault. We don't even have to consider a payment. And even though the other side might be 49% at fault for damaging your car, you are now either self-insured for that or you get 0. I don't know that anybody thought about that, but I think that's going to be a big, big issue, okay? But also this rule then is meant to bring the first issue in any case now as fault. Okay, what does that mean, fault? Well, we've talked about what you have to prove to show the other party's responsible. So if you, as a plaintiff, have to show you're less than 51% responsible in every case, how do you do that? That's going to require a whole lot more investigation than there used to be because, I'm not going to say it's subjective, but trying to figure out whether somebody's 25, 50, or 75% responsible in that range is not a very factual experience. It's subjective. It's in the eye of the beholder. So how do you protect yourself? Well, dash cams, they will record the events and they'll be available to you regardless of how injured you are after the accident. Because most people who are hurt in a car crash are not going to be thinking after the fact of trying to take pictures or video or entertain witnesses about what happened, period. They were worried about getting better. And we now also have the scenario, which we have talked about, where many metropolitan police companies, departments or whatever, will not respond to car crash cases unless they think they are at a certain level. So you not even have an independent outside entity trying to do the basic investigation. And yet we're focusing now on people's rights, serious rights to them that have been involved in this crash. Where does this information going to come from? I don't know. We have some technology now, so that's great. And I think if you think about it, is it going to make it cheaper? Is it going to make it better? I think it presents the insurance companies an easy way to deny a claim, but I think it's going to generate a whole lot more litigation in cases where there are people who have had a significant injury. That's just my thought. I don't really think that this was all thought through. And why it only applies to car accidents is another, we're talking about politics. So we'll leave that issue, the issue about comparative fault and how significant it is when we talk about another change, because if you go to trial, this fault issue is also very important, okay? But let's go to the second thing they changed. The comparative fault was changed for car accidents only, but for most of our listeners out there, I don't even think that, regardless of whether you are less than 51% at fault or that the other party is 100% at fault, however you want to phrase it, you still have to establish a qualifying serious injury under New York's law that's been in place in a previous tort reform back in 1976. This law was put in place allegedly to control insurance costs, to lower insurance costs by restricting people's ability to sue, by requiring a qualifying serious injury. And did that statute work? No, it didn't work. It doesn't work, and it hasn't worked. And so now we are compiling on, because we have now eliminated in this legislation one of the more simple provisions for you to qualify with a serious injury, the so-called 90 out of 180-day rule. It's more complicated than that. But that was eliminated by the legislature, making it more complex, more convoluted to prove a qualifying serious injury. And all this process, this qualifying serious injury threshold, was put in place in 1976, along with the entire no-fault regimen, because the claim was that we are going to give no-fault benefits to people with so-called minor injuries, and that they are giving up their right to sue for those so-called no-fault benefits. None of that has worked out. in my opinion. I don't think it works. It hasn't worked. And it certainly hasn't kept insurance rates low. And by the way, we are one of the few states that have this kind of system in place. And our rates are significantly higher than states that do not have that. So, yeah, I guess you decide for yourself. But, you know, compiling on these tort reform provisions without thought, hopefully saving the insurance companies' monies doesn't seem to be the way to go. But that's the way it is. And if you want to spend some time getting yourself totally confused, you could pull up insurance law section 5104 that has the remaining elements to qualify for a serious injury under the New York law. And then you could figure out what they mean and see if you're right, because there's probably 10,000 court decisions trying to define what they mean, but read it. The words kind of make sense, sort of, maybe, unless you're a lawyer and a jury and a judge, because the words end up being just a big convoluted mess. One more thing they did change, and this goes back to the comparative fault issue we talked about, which I don't think was ever thought about. The first thing now the juries decide in a car crash case is fault. Now, before this change, it was kind of a strange rule. The jury decided whether you had a qualifying serious injury first before they decided if the other party was at fault. Okay, that's the way it was. Now the juries decide fault before they consider whether you have a qualifying serious injury. Does this help the insurance company? I'm going to say that if they had thought about it, they would probably say no, because in a litigated case, it's going to require much more showing about actually what happened and what the motivations were of the parties. And I also think that if a plaintiff persuades the jury that the other party was at fault, the awards on the serious injury category might turn out better. I always thought that the way they did the rule, the old way, was beneficial to the insurance companies. I always thought that having the jury decide whether you had this crazy qualifying serious injury, something they really didn't understand, and I could see why, was far more difficult for a plaintiff than proving fault. So, again, the law of unintended consequences. Where do we go and how does this end up? We shall see. We shall see. And as one final thing that was thrown in here, I don't think it comes up very often. There's now a $100,000 cap on pain and suffering awards for uninsured drivers, impaired drivers who've been convicted or those committing a felony at the time of the crash. Those aren't a lot of categories. And, I guess that you punish them only a little. We can only get 100,000. Again, I don't know where that came from, but it doesn't happen very often. So in summary, what do we get? What do we get? We have tort reform, whatever it is you want to call it. It's rules that the insurance companies wanted because they're claiming they're going to lower their rates. I don't think so, but I can tell you that if you are involved in a crash, it behooves you to call us early to help you through figuring out what is important to know and what information is important to get, particularly video. There's video in almost every place now, at least in urban areas, and they're only preserved for a very short period of time. It may come to be that those videos are even more crucial than they are today. And so I think it's important that you contact somebody to help you out, because this makes it virtually impossible for someone to handle a case on your own. Because if you try to go it on your own, you're going to go down the drain. And the insurance companies may just totally ignore you now, given these advantages they have. So that's where we end on the car crash side of things. And those were the most significant changes to the law.
Construction sites are dangerous places. A fall, an unmarked hazard, someone's negligence, your injury. The Stanley Success System fights for your maximum award. StanleyLawOffices.com, 1-800-608-3333.
Now we go into the workers' comp part. Now, workers' comp has always been another one of the insurance companies' whipping boys, because they're always trying to find a way to lower premiums. They're always saying that the benefits paid to their injured parties are too much, and the workers' comp premiums are too expensive. And this has been going on for a very long time. And there have been tort reforms aimed at the comp system off and on during my career. And now what you're really talking about in workers' comp is limiting benefits for injured workers who are injured on the job or in the course of their employment. And that's part of the contract as an employee in New York. You give up your right to sue your employer for these workers' compensation benefits. That's it. That's your only claim, all right? And year in, year out, they try to reduce them, try to reduce the length and extent and the amount. And is that fair? Because for a lot of people, the only remedy is workers' comp. And if that doesn't make you whole, that means your job has reduced your ability to function without compensation, which I think most of us would agree doesn't seem fair. But what happened? What did they do in this governor's marvelous budget? Well, the weekly comp benefit is going up a little bit. It's indexed starting in 2026. So the maximum benefit goes up on inflation, and that's indexed, which is a good thing. So, I mean, for a while it was not. It was frozen. And the minimum benefit is also now going to be indexed, which was the minimum benefit. And it's hard to, a $150 minimum benefit is the very few scenarios where the minimum benefit would come into play. But there are some, but now it will at least be increased. By the way, $150 a week, you add that up, that's $600 a month. In this day and age, that's not going to get you anywhere. In fact, get you nowhere pretty much. But that change is really inconsequential. They didn't really do anything else to the law, thank goodness. But you still remember, it's capped unless you have a permanent total disability in the extent and the amount of money you can recover. Your medical expenses still are not capped, and they can go on for life, but it can be a lifetime battle. One of the things that the government and the insurance companies have tried to do over the years is to make the system such that everyone will settle out, so to speak, and not be part of a benefit system for an extended period of time. So if you're hurt on the job and you're offered a settlement, you need a lawyer to talk to you about what your rights are, what you should get, whether you should do it. And that should be an informed decision by you and a knowledgeable lawyer who's familiar with the system, because settling your workers' compensation case has all sorts of consequences, both good and bad. Access to medical care if you didn't know it, any doctor now can treat a workers' compensation claimed patient if they so choose. The law before this, for some unknown reason, required a physician to be certified with the board, and that limited the amount of doctors who are available. The biggest limitation now, by the way, I'm not sure how much this is going to help, because the workers' compensation reimbursement rates are still incredibly low. And when I say incredibly low, they are incredibly low. They're the same rates, by the way, as the no-fault reimbursement rates. And if doctors and hospitals and physicians have a chance, they will bill a different source for their treatments because the reimbursement rates are generally higher. So interesting about how this whole system works. What the takeaway is, whether you're in a car crash or you have a workers' compensation claim, you really need someone to help you navigate you through the system, because nothing has been made simpler. And a lot of these issues are very personal for you. You're the one who's hurt. The limitations and the crazy rules are not meant to protect you, the injured party. They're meant to protect someone else. They're meant to protect the system. They're meant to protect the pocketbook of the insurance companies. So you need to understand that if you don't navigate the system and navigate it in the right way, you may be penalized without any fault on your part. So this is even more necessary. I mean, I say this is like a lawyer's full employment act, because they make these changes. They never make them simpler. They never do. And I really think it's imperative that if you're involved in one of these scenarios, you can contact us. We do both workers' compensation and personal injury auto crash cases, and we understand the law, and we understand the complications or the complexities, and we try to make it simple for you to understand, if that's possible. Finally, thank goodness, there was no changes to the New York construction law. Now, this has been a constant attack. It's called so-called scaffold law, but it's really much more than a scaffold law. Is still in effect, and I can say that for the last 15 years, this was the number one target of insurance companies and lobbyists for changes. And fortunately, no changes have been made. And so that the rights of injured construction workers or people who do construction type work are still protected by the New York labor law sections 240 and 241. And maybe they were too busy focusing on the car accident changes. I don't know, but they didn't put up much of an effort this year. But I guarantee next year they will be back. They will be back. They will be back because, by some count, New York City construction accident payouts through Section 240 of the labor law reached $1.1 billion. That's a lot of money that goes to injured workers. And it's very important that these provisions stay in place. Now, 240, 200, 241, they're different provisions. They cover different activities, and they cover different kind of work environments. 240 generally covers construction workers or construction type activities, repairs, amendments, and whatever. There's a whole series of definitions in the law, but it's construction type work, cleaning, repairing, alterations, etc. Painting and pointing are also in there. But they have to involve some kind of a fall. a lot of law involved in that, a lot of convoluted law. And if you're in that scenario, you need to hire a lawyer. And we are very familiar with the ins and outs of that section. And it's imperative, again, because of the intricacies of that statute, that you get a lawyer as soon as possible to investigate exactly what happened. And the main reason is that information goes away very fast, but also the responsible parties, the owners and the general contractors, have gotten far better at cleaning up the scene after a construction accident. Section 241.6 applies solely to construction work, which is a little bit narrower than the 240 provisions we just talked about. And they have a different kind of convoluted structure of the law. The Section 241.6 has regulations that were passed in 1970s. See, we go back to the 1970s, but that, by the way, have been inactive since the 1970s, have not been amended. In fact, are not used because they were superseded by the OSHA regulations, but they still apply to your ability to recover on a construction type accident case in the year 2026. And so that's why it's important. You have to come within one of those regulations to be able to bring a claim to recover. And the final one, Section 200, is really a codification of a common law duty for owners and contractors to provide a safe place to work. There's different even rules that apply to that. And we could spend a podcast or two on each one of these provisions, bore you to tears. Wouldn't want to do that, because it's just important for you to know these provisions are out there, that you need to talk to a lawyer. Call us right away, because it's important that your rights get protected. And most injuries on a construction site are not minor. And it's important that you preserve your rights, because, as we talked about, workers' compensation only pays a small percentage of your total damages if you suffer a serious injury on a construction site. And this statute is meant to give you protection for all those other injuries you have suffered. If you're hurt on the working or you're hurt on the job, construction statute isn't the only way to recover. If someone else is responsible who is not your employer, who somehow was partially caused your injury, then you can bring a claim against them and also collect workers' compensation benefits. So that's always something that is important to investigate when you're hurt on the job. Was it somebody else's fault besides a co-employee or your employer? Again, because workers' compensation is limited. So, the law has changed. Law is always changing, sometimes for the better, sometimes for the worst. And I think in this case, the changes are generally detrimental to injured parties, okay? I think they have made the recovery more complicated, more rules, more evidence, and more expense. And the ultimate expense is, and I think that's the goal of the insurance companies, is to make the cost of going to trial so prohibitive that small and minor claims to them, but they're not small and minor to you, will go away, so they don't have to pay them, so that you just self-insure for somebody else's negligence and you suffer the consequences because they don't want to pay. That's not the way it should be, and I don't think the way that as citizens, that's what we voted for, but that's what we have. So if you've been involved in a car crash, construction crash, or any kind of personal injury, give Stanley Law a call right away. We know the system. We have a Stanley Success System, and our specialized paralegals will get to work with you and our lawyers to get you the maximum award.
Here at Stanley Law Offices, our approach is a little bit different than other law firms. Immediately when you call our firm, we're on it. The paralegal reviews the case with an attorney, we review the case, and then we see right then and there if this is something we can help you with or not.
Each case is different, so it's important to understand the nuances. Each person is different and they require different needs, so it's important to evaluate what those needs are, see if the client has any questions or concerns to ensure that they are addressed in a timely and efficient manner. Stanley Law, the maximum award people.